only one thing remains: payment of area difference amount on account of this promotion. That can be paid only by Ranchi University.
Is that so? Ranchi University will pay this? Who is for Ranchi University?
My lord, Ranchi University is not a party, but let me assist this court on that point. We have written 3 letters to Ranchi University in that regard. I have got the copies of those letters. I would like to place on record through an affidavit. It has not been done in affidavit, but it is ready with me. 3 letters we have written.
Registrar Ranchi University was a party in the writ petition. You have not made them party.
Because the order was passed with regards to the state and Quran university.
Not in the contempt of
the order.
You make the registrar Ranchi University as party and let us take it from there. आपने तो कुछ फाइल किया है.
Madam, but before coming to this court, I talked to Ranchi University. They have received the letter of Quran University. He must make Ranchi University a party. They say they will pay it within a month or so.
But
Yes,
इतने एज हो गया ना अब इसको
इनको पार्टी बनवा दिए वैसा.
आप रजिस्ट्रार रांची यूनिवर्सिटी को पार्टी बनाइए. I will take this statement from him that the matter is now pending before the registrar Ranchi University. उसके बाद मिस्टर मेहता अपीयर करते हैं generally for Ranchi University.
My lord, I have filed an affidavit to that effect that we have written along with the copy written to the Ranchi University. That my lord, my.
No, that's okay. I've seen that. I've seen that. I've seen that.
After that we have written.
उसके बाद रांची यूनिवर्सिटी को रजिस्ट्रार को हम डायरेक्शन देते हैं to file an affidavit. अब now the ball is in his court, so he has to respond. उसके बाद रांची यूनिवर्सिटी के पास स्टेट के पास जाएगा क्या?
नहीं, state has done it.
Yes, state has done the needful.
State thereafter Quran University has notified.
Yes.
Now बोले कि
Ranchi University has to pay.
Quran University का सिर्फ हम notify करें but payment I will not.
Payment Ranchi University.
इसलिए हम बता state government has issued an order.
ठीक है, दोनों आपस में निपटेंगे ना, पेमेंट किसको करना?
पेमेंट हो जाएगा.
Contempt Civil 266 of 2025. Pursuant to the last order, the registrar, Jharkhand University, is personally present in this court. The counsel for the counsel representing registrar Ranchi University, Jharkhand University, has referred to the show cause filed by him dated 13/10/25. And has submitted that, and has referred to the letter dated 9/10/25 annexed to the show cause, and has submitted that needful has to be done by the registrar Ranchi University. He submits that the registrar Ranchi University is not a party in the present proceedings. However, he was a party in the writ proceedings. Counsel for the appellant petitioner is directed to add the registrar Ranchi University as opposite party number 4. In the as opposite party number 4, and is directed to serve 2 copies of the entire records of this case in the office of Mr. A.K. Mehta, who is a retained counsel of Ranchi University, along with a copy of this order. An affidavit on behalf of the registrar Ranchi University be filed within 15 days as to what steps have been taken to ensure payment to the petition. That's it. The personal appearance of the registrar Jharkhand University is dispensed for the present. 5 तारीख को रख देते हैं. 5th of December, the affidavit of Ranchi University be filed latest by 2nd of December.
I will serve next Monday copy.
आपको पैसे की हड़बड़ी नहीं है, आप उसको सर्व करिए ना पूरा. विनीत जी ये ऑर्डर हमसे साइन करा लेंगे लंच टाइम. ठीक है, आप आज करिए सर. फाइल है ना आपके पास?
कॉपी ऑर्डर कॉपी
कोई बात नहीं, ऑर्डर ऑफ कॉपी आपको मिल जाएगा, दोपहर को मिल जाएगा. नहीं तो मिस्टर मेहता को बोलेंगे ना, ऑर्डर हम भेज देंगे, लेकिन उनको तो आगे फॉरवर्ड करने के लिए नहीं जाना चाहिए.
Order settlement CMP 318 of 2007.
What is to be done now for this?
Restoration of 38.
Restoration of?
CMC number 38. इसमें जितना आए हैं
अब हो गया ना कहानी इसका खत्म, सब्स्टिट्यूशन
सब्स्टिट्यूशन हो गया सर।
अब इसको रेस्टोर करना है।
हाँ, इसमें भी एक लिमिटेशन पिटीशन हम जिसमें 516 डेज का देने के लिए हम फाइल किए, जो आए नंबर 2109 of 2007। हाँ, दो बटन भी डाल रहे हैं, बाकी बनाए 717 और सब इसीलिए both IS have no relevance now. ये पूरे गैप में 2109-2007।
आपको कोई डिले में ऑब्जेक्शन? और कौन सा आई है?
बाकी आए सब्स्टिट्यूशन के लिए हैं, लेकिन सब 717 में सब्स्टिट्यूशन कंप्लीट हुआ, नोटिस भी कंप्लीट हुआ, अपीयरेंस इसीलिए 2000
उसमें हो जाएगा कंप्लायंस, तो इसमें ऑटोमेटिक कैसे
ऑटोमेटिक हो जाएगा।
ऑटोमेटिक कैसे हो जाएगा? नोटिस तो करना ही पड़ेगा ना।
एक बार तो हो गया।
नहीं नहीं नहीं, एक रेस्टोरेशन में पार्टी हो गया, अब इसमें
हम सब
नहीं होगा। नहीं, आप सबको सब्स्टिट्यूट करिए, आप उसमें जो जो सब्स्टिट्यूशन जैसे सिटी आपको सबको करना है। फ्रेश नोटिस में
717 इसके बाद भी जो लोग मर गए
वो
उन लोगों को हम 717 टोटल सबको किया गया है।
सभी को करना पड़ेगा, ये सब कुछ आपको फिर से करना पड़ेगा, नहीं कर सकते हैं ऐसे नहीं होगा।
जो सब्स्टिट्यूशन हुआ वो
ऑटोमेटिक नहीं होता सर, पार्टी तो बनाना पड़ेगा ना, नोटिस तो करना ही पड़ेगा, उसके अलावा कोई उपाय नहीं। उसमें जो जो सब्स्टिट्यूशन है सबसे टैली करके सबका एक फ्रेश पिटीशन इसमें फाइल करिए, नाम में बहुत एरर था, क्या क्या था, सारा कुछ उसमें रिजॉल्व हुआ है, ठीक है। उसके बाद इसमें आप बनाइए पार्टी, इसको नोटिस होगा तब होगा, ऐसे नहीं होगा। हाँ, आपको सारा वो नाम सब टैली कर रहे हैं,
सब है।
हाँ, आपको फाइल करना है, कुछ नहीं कर सकते हैं सर।
जो 717
ऑर्डर डिफेक्टिव हो जाएगा, सुप्रीम कोर्ट से सेटिस्फाइड होगा, एक ही चीज बोलेगा कि हमको बिना सुने हो गया, बस कहानी खत्म। CMP number 318 of 2007. Counsel for the petitioner seeks adjournment to file appropriate petition. कितना टाइम चाहिए बताइए, इसके पहले कि दूसरे लोग मर जाए।
3 सप्ताह
At his request,
अच्छा 2 सप्ताह
at his request, post this case on 28 नवंबर। सर अभी इसका कहानी शुरू हुआ है, इसको खत्म करो।
हाँ, इसीलिए हम भी इसमें इक्विप हो गए।
हाँ, एक बात जो है ना, उसमें से आप टैली कर लीजिए, मेरे ख्याल से नाम में कोई एरर नहीं होगा। देखिए फाइनल ऑर्डर में हमारे यहाँ सबका नाम लिखा रहता है।
हाँ, उसको हम चढ़ा के दिए।
हाँ, सबका नाम लिखा हुआ है, इसीलिए सबका नाम करके आप सबका सब्स्टिट्यूशन फाइल करें। और चूंकि यही है तो हो सकता है इनको इंस्ट्रक्शन मिल जाए अपीयर होने के लिए। He will seek instruction. The moment you file, he will seek it. आप भी इंस्ट्रक्शन ले लीजिए।
पार्टी बना देंगे।
हाँ, ठीक है, आप आइए फाइल करिए, तुरंत इंस्ट्रक्शन।
हाँ, आए।
In the meantime, you just tell them that this is what is happening, right?
Item 13 CMP 713 of 2025.
ठीक है अच्छे से। Petitioner absent. Post on opening Saturday. Opening Friday. या सैटरडे भी आने वाला है ना?
6. 6th December.
6th December.
Item 14, CMP 858 of 2025.
मुझे इसमें नोटिस हो गया है and the party has appeared and I has 5% resolution of delay and that is delay of 1
One, delay of
1440 दिन का delay होगा I have assigned a decision in para
पढ़ी, para 3 पढ़ी. When was it dismissed for default?
this is for due to non-decision
When?
on 17/5/2019
Non-prosecution means
concerning the notification of attending उसके बाद COVID-19 हुआ and thereafter this was filed and that demand of liberty was given by this honorable court to pursue the remedy execute the that is why CMP has been filed for restoration. But there was delay of 1 year.
any objection? Who are you? You are the present respondents. CMP number 858 of 25 with ID number 12321 of 25. Nobody, counsel for the petitioner is absent. Nobody appears on behalf of the respondents, in spite of service of notice and having filed for contempt. Counsel, IA number 12321 of 25 has been filed seeking condonation of delay of 1446 days in filing the application for restoration. The first appeal number 13 of 2018 was dismissed for default slash non-prosecution on 17/5/2019. And in the meantime, there was COVID-19 situation, and the reason for condonation of delay has been explained in paragraph 3 of the interlocutory application. Being satisfied with the cause shown, the delay in filing the petition seeking restoration of first appeal is hereby allowed. आइए नंबर 37 से आगे बताइए.
CCL has a guideline and in percentage it's a real owner. But I am the real owner. I am in the position. But the registry has ready to make and compensation award has been awarded to the opposite parties. And that is why I am agreeing. Land is still in my position.
आपका डिसमिसल ऑर्डर किधर है? ऑर्डर ऑफ डिसमिसल किधर है? दिखाई जरा फर्स्ट अपील करो. इसमें तो बहुत सारा केस डिस्पोजल हो गया होगा. इसमें बहुत सारा केस डिस्पोजल हो गया होगा ना, एलआर केस.
इसी ऑर्डर के अगेंस्ट में हमने यहाँ आए. आई एम चैलेंजिंग द ऑर्डर ऑफ 17 अगस्त 2017.
आप डिफेक्ट फर्स्ट अपील में कितना दिन में रिमूव करेंगे? आर यू फॉर द रिस्पोंडेंट्स? आर यू फॉर द रिस्पोंडेंट्स? आपका अपीयरेंस रिकॉर्ड करें कि ना करें? इनका डिले का नोट कर दें. ठीक है. अब फर्स्ट अपील में नोटिस हुआ था, ही डिड नॉट कंप्लाई. फर्स्ट अपील रिस्टोर कर देते. आपसे गलती नहीं हुआ क्या लाइफ में कभी?
मेरिट पे कभी नहीं है, सबसे
Merit पे
गलती होता
लड़ेंगे?
है, हम लोग भी गलती होता है।
ठीक है, चलिए इनका इस पे भी उनका लिमिटेशन पे कर दीजिएगा, अपीयरेंस रिकॉर्ड कर दीजिएगा, वो सब लिखे ना नॉन अपीयरेंस हो सकता है, काउंसिल फॉर द पार्टीज पर आप प्रेजेंट कर दीजिए। CMP number 858/25 has been taken up with the consent of the learned council for the parties. This petition has been filed for restoration of FA number 13/2018, which was dismissed on account of non-compliance of order dated 6/1/20, non-compliance of order dated 17/5/2019. The learned counsel for the petitioner, appellant, petitioner has submitted that the order was not complied due to inadvertence. And if the first appeal is not restored, the petitioner shall suffer irreparable loss or injury. Hearing the counsel for the opposite party has no serious objection so far as prayer for restoration is concerned. After hearing the counsel for the parties and being satisfied with the foreshown, the defect था
ये सब 5 कॉपी और सब बहुत सारे
just the कितना टाइम लगेगा आपको इस ऑर्डर को कंप्लाई करने में? 4 weeks time is granted to the petitioner to comply. Further 4 weeks time is granted to the petitioner to comply the order dated 17/5/2019 passed in FA number 13 of 2018. CMP number 858/25 is allowed in their proceedings. वो फिर से प्रीएम्प्टिव नहीं करिएगा, फिर से डीएमडी हो जाएगा। वो आप जानिए, आप अभी तो आप रिकॉर्ड ही नहीं पता क्या क्या डिफेक्ट है। बहुत अच्छी बात। इससे तो सारे केसेस डिस्पोजल हो गए होंगे इससे रिलेटेड। जब देखिए तो उसको खोलकर लैंड एक्विजिशन से रिलेटेड है, ये सारे केसेस इम्प्यूग्न ऑर्डर से ही पता लग जाएगा। लैंड एक्विजिशन केस है धनबाद का, रांची का है, वो रांची का है। और लोग के लैंड एक्विजिशन का केस फाइल नहीं किए यहाँ पर।
बहुत सारा केसेस में 5 नाम केस नंबर 5
पता करिए उसको, उन लोगों को बोलिए चलिए एक्सप्रेस को। If this order is complied, office is directed to immediately list the first appeal before appropriate bench as proposed. कुछ नहीं हुआ, चलिए follow करिए।
Item 17, contempt civil 795 of 2022 along with item 18 and 19.
This matter, Lordship, the demand drafts has been, Lordship, deposited in the favor of registrar and the Jharkhand, Lordship. So it can be, an application can be given by the petitioners and same can be reviewed by the petitioners, Lordship, with permission of Lordship.
Okay. डिमांड ड्राफ्ट उन्हीं के नाम से था,
रजिस्ट्रार देगा झारखंड हाईकोर्ट, उनके अकाउंट में डिपॉजिट हुआ है।
क्रेडिट हो गया है। नहीं बोलते क्रेडिट हो गया,
क्रेडिट हो गया।
क्रेडिट हो गया है। तो you move the contempt civil 795 of 2022. The learned counsel for the opposite party has submitted that the amount as directed by this court by order dated
10/5/2023.
10/5/2023.
3. Paragraph 8.
10/5. Ten 5/23 has been deposited before the High Court in the name of through demand draft
Yes.
in the name of Registrar General of this court. He has also submitted that the amount has already been credited in the account of learned Registrar General. He has also submitted that the petitioners may approach the learned Registrar General for disbursal of the amount in terms of order dated 10/5/23. Right? The LP has been dismissed in all the three cases.
No, Lordship. One is
कहाँ पे था कुछ सिक्योरिटी देने बोले थे ना? कौन सा आपको permitted to withdraw subject to bank guarantee? And the attention of this court has also been drawn to the order dated 28/2024, wherein this court had directed that the petitioners are permitted to withdraw the amount which has been deposited before the learned Registrar General, subject to furnishing bank guarantee of a nationalized bank, valid for a period of 6 months to be kept alive. सब में से LPA डिस्मिस हुआ, सुप्रीम कोर्ट गए हैं, किसमें LPA डिस्मिस हुआ?
569 and 570 of 2020.
LPA number
569
569
and 570
and 570 of
2020.
2020 had 23 has been dismissed, and no SLP has been filed in these cases. So far as LPA number 613 of 2023 is concerned, the same is said to be pending. Since LPA number 569 of 23 and LP number 570 of 23 are ultimately dismissed, the writ petitioners in those cases are permitted to withdraw the amount by filing an application before the learned Registrar General, which shall be disbursed subject to satisfaction of the amount to be disbursed. The counsel for the opposite party shall assist the learned Registrar General in the matter so that the amount relatable to those writ petitioners is only disbursed. तीसरा LPA का क्या करें?
Same and similar session order was passed by all these cases.
So far as the writ petitioner in LPA number 613 of 2023 2023 is concerned,
It's currently covered by FOCA.
is concerned, the petitioner shall furnish bank guarantee if he, the petitioner shall furnish bank guarantee in terms of order dated 28/2024 in case he wants to withdraw the amount during pendency of debt. आप एक्सपेडाइट करिए, आपको कौन मना किया?
No notice has been issued.
आपको नोटिस का क्या जरूरत है? एलपीए अपीयर हो जाइए, वकालतनामा फाइल करने को कोई मना किया? आप दीजिए 1 नंबर कोर्ट से कि सब में ऑर्डर हो गया है, हमको वकालतनामा फाइल करने का परमिशन दीजिए, मना कर देना तो कोर्ट ने मना किया। हमको जुरिस्डिक्शन है बोलने का कि आप एलपीए डिस्पोजल कर दीजिए।
नहीं बोल रहे हैं
तो कौन से तो the dispersal will be in favor of the petitioner in connection with LP number 613 of 2023 will be subject to the final result of the LP. These contempt proceedings are accordingly disposed of.
regarding contempt 795 minute
795 कौन सा है?
उसका
उसका LPA डिस्पोजल हो गया ना?
नहीं, उसका LPA पेंडिंग है।
LPA नंबर 613 और 2023 पेंडिंग है ना? सारा डिस्पोजल कर दिया। आपको पैसा चाहिए?
नहीं तो he is not able to furnish the bank guarantee.
एक और चीज लिखिए। In case the petitioner in connection with LPA number 613 of 2023 is not able to furnish the bank guarantee as submitted by the counsel for the petitioner, he shall be entitled for withdrawal of the amount if the LPA number 613 of 2023 is dismissed. सब डिस्पोजल कर दो।
इसको पेंडिंग है।
पेंडिंग का कोई काम ही नहीं, फिर कॉल करो।
Item 21 CMP 631 of 2023.
Restoration of who's for the respondent? CMP number 631 of 23. Counsel for the parties are present. This petition has been filed seeking restoration of WPS number 5358 of 2019, which has been dismissed on account of non-removal of defects in terms of order dated 21/10/22. The learned counsel for the petition has submitted that the defects could not be removed on account of inadvertence. Counsel for the opposite party has no serious objection so far as restoration of the petition is concerned. After hearing the counsel for the parties and being satisfied with the cause shown, the time for removal of defect as granted by the order dated 21/10/22 in WPS number 5358 of 2019 is extended till 19th of December 25. If the defects are removed within the extended time, the office is directed to place the petition before appropriate bench as per roster in the appropriate bench as per immediately list. Okay? CMP is accordingly disposed.
Item 22 contempt civil 669 of 2023.
The state has definitely
Against which order?
passing LPA number
LPA number Where is the LP order?
LP number 235 of 25. Order detail number 27.
235 of 25. Right?
235.
Date.
The order number 4725.
4725. SLP number.
Then the dial number is around 60320 of 25.
60320
Of 25.
25. LP number, this one. Content civil 669 of 23. The learned counsel for the parties are present. The learned counsel for the opposite party. आप कौन है? यह फाइल वकालत था ना? A counsel for the opposite party has submitted that LPA number 235 of 25 arising out of the judgment passed in the petition relating to this case has been dismissed on 4/7/25, against which SLP has been filed through diary number 60320 of 25. The learned counsel seeks adjournment. Pose this case on 5th of January 26. So opening Saturday क्या date है? Opening Friday. 9th of January. 9th of January 26. The counsel for the opposite party shall apprise this court regarding the present status of SLP. The office is also directed to legal legal and prepare appropriate office note.
Item 23, Content Civil 915 of 2023.
Petitioner. Done.
The notices has been issued by dated 6/10, edition 13/10 was fixed for doing the needful for spot verification. And I has been filed edition which is IA number 14540 for plan to further 4 weeks examination.
4 weeks time for what? What is the new date to be fixed?
No, that's being carried out.
No. What is the new date to be fixed for appeals?
So for doing the needful revision.
What?
We've done,
You see, you had fixed a date. You could not do it because of heavy rain. What is the new proposed date?
today is
पूछ के बताइए. ऐसे नहीं होता.
I
You give me the new proposed date. I'll put it in the orders. So the parties act accordingly. Date, time दोनों बताइए. 12 o'clock. 12 बजे. 12 बजे भी टेकअप होगा. समझ आई बात? मिस्टर मिस्त्री आपको बोल रही हूँ. 12 बजे टेकअप होगा.
Item 24, Content Civil 985 of 2023.
क्या प्रपोज है? इनको रिप्लाई फाइल करने का जरूरत पड़ेगा.
Showcase we have already the reason order has been passed over.
अब रीजन ऑर्डर के बाद क्या बचा?
My lord, the region order, my lord, this is the third region order, my lord. And without, my lord had made me query, my lord, before making any inquiry, my lord, they had to institute a particular case number, my lord, institution of a particular case number. Till date, they have not done, my lord. And as per my instruction, my lord, the document which has been submitted by these petitioners, my lord, still they have not considered, my lord, only few of the documents they have referred, and from their own reports, my lord, they have done nothing, my lord. So, my lord, nothing, my lord, and no action as it is. So, therefore, only 1 week time, my lord, not more, my lord. Within 1 week, I will find. Within a week. 1 week.
Content civil 985 of 2023.
This means not a fresh notice, but all the procedure has been followed, and again the reason order
Let
has
him,
been.
let him speak. Counsel for the parties are present. Counsel for the petitioner prays for time to file a response to the third show cause filed by the opposite party. Post this case on 9th of January.
Item 26, Contempt Civil 131 of 2024.
This petition. The file is
In this
open.
case, the last order is kindly similar. 17th October 2025. Earlier also mirror 29th of August 2025.
Yes. Whom are you addressing?
And for this election under the state, it is a formal party. State Food Corporation is the main answering respondent.
OP number 2.
Yes, notices are issued upon, earlier also notice to be issued upon this file number 2.
On the last date,
They have appeared in 29th August 2025. Thereafter, this order was passed.
he is not appearing. OP number 2 is not appearing.
Not wrongly जो नाम दे दिया गया उन्हें
On the earlier occasion, my colleague did not appear, and then time was granted they under 225, so 29th August. Then it was repeated in 17th October.
What information do you have?
He has informed me that his name is wrongly mentioned in this case.
Wrongly mentioned? His name is not mentioned. Where is it mentioned?
मनोज कुमार चौबे
इस ऑर्डर शीट में तो कहीं नाम नहीं है.
लिस्ट में आ रहा है, लिस्ट में आ रहा है.
On 29th,
OP number 2 was served.
yes, notices have been issued pursuant to order dated 29th August.
State Food Corporation, Sahibganj.
Yes. District manager. District manager, State Food Corporation, Sahibganj.
Who represents State Food Corporation, Sahibganj? State?
There's a different council for the state.
No panel council must go. See, there is a notices were issued. Notices.
Mr. Bakshi appears?
No,
He appears for Food
not the
Corporation.
civil order. I State Food Corporation. That is he represents.
You seek instructions, madam.
Okay.
ऐसा नहीं कि हमको सर्व हो गया notice, he is not appearing. We have no option but to issue bailable warrant.
Okay, Rashid, please.
In spite of service of notice, if somebody is not appearing in a contempt proceedings, we have no option. You want that?
We will follow up in this.
Earlier also this was done on 17th October. And that is the reason it was raised.
थोड़ा सा इत्मीनान से समझा देंगे. ऐसे वारंट इशू होता है तो न्यूज़पेपर रिपोर्ट बनता है. ऐसे कोई हम लोग को कोई इंटरेस्ट नहीं. We are not interested.
कोई इंटरेस्ट नहीं.
किसी को कोई इंटरेस्ट नहीं है. नोटिस दिए हैं, अपीयर नहीं होंगे तो क्या करेंगे? वो भी कंटेम्प्ट प्रोसीडिंग में. You seek instructions, find it out. अच्छे से चिट्ठी लिख लीजिएगा,
Yes.
right? And if he still does not respond to you, in fact, you should communicate through the deputy commissioner.
Yes.
Deputy commissioner or the secretary, because the notice has already been served upon him. जो भी आपके फूड डिपार्टमेंट के सेक्रेटरी होंगे, डिपार्टमेंटल हेड के थ्रू कम्युनिकेट करिए. इस बंदे को अभी समझ नहीं आ रहा.
You will write the letter and you-
Yes, हो सकता है ट्रांसफर हो गया हो. We do not know. नया इनकम्बेंट आ गया होगा, तब पता नहीं चला.
One thing is really particular. She may communicate to the deputy commissioner to serve it to the existing post holder.
You
It
communicate.
We will follow up.
It will be mentioned in the order sheet otherwise.
Contempt case civil number 131 of 24. In spite of service of notice upon opposite party number 2. The counsel for the state is clueless and has no instructions from opposite party number 2. Correct? No instructions तो है ही ना.
As per our information, there is an independent panel lawyer for the State Food Corporation.
नाम बताइए ना.
But I don't know the name.
So you are not representing state.
Most probably as per our file routine, we are not representing state food corporation.
Okay. The Learned Council for the state has submitted that the state is not supposed to represent the authorities under state food,
Your addition,
Jharkhand State Food
your
Corporation.
addition can be submitted in one year. I have to seek instruction. If we are posting for the
अच्छा,
I will
just a
ask
moment.
my senior
Just a moment.
whether we will
The
represent
फिर से
them or
लिखिए,
not.
है ना? The Learned Council for the opposite party state has submitted that some time may be granted to seek instructions, and she shall take up the matter with the opposite party number 2 through the deputy commissioner of the concerned district, so that he may appear or give instructions to the council for the state, right? And file show cause in the matter. Post on 5th of December. You need more time?
We will communicate.
Post on 5th of December. It has been reported that the name of Mr. Manoj Kumar Chaubey is wrongly reflecting from the side of the opposite party. Let his name be deleted from the comments.
Item 27, contents with 483 of 2024.
On 15th October 2025, a surplus has been served upon him. Unfortunately, petitioner who is lying on bed under treatment. So only one opportunity to resign because there is a dispute now they have raised. It was a case where the departmental appeal was directed to be disposed. Now they were proceeding, they took time. Now they have taken a plea.
Content case civil number 483 of 24. Counsel for the petitioner seeks adjournment. Post on 9th of January 26. By way of last indulgence.
Item 28, contents with 631 of 2024.
Kindly see the order dated 19/9/2020. Last one.
19/9/25.
Units.
What is it?
The respondents were directed to at this stage Learned Council for opposite party place for time and submit as necessary verification will be done in respect to recognition letter annexed with the reply.
Yes, what have you done?
Madam, we have sent them a letter, madam, asking them their reply, but the reply is not specific, madam. In that I have annexed in Excel 3 of my proposal also. They are giving us a vague reply. We have asked particularly, you tell me regarding that period.
Who is that person who is not able to understand your letter? Who is that
They are
person?
the RPDF University Bhopal, madam. They are not able to provide us the specific that.
See that.
Whether it has been recognized in that academic year of 2012 or 13 or 13 to 14 like that. That is why we are unable to go forward.
Okay. In that case, do you propose to make them party?
Yes, I have created that also.
Your leadership may kindly see that one because that letter is very clear. It is the DSC who is not understanding the reply. Your leadership may kindly see page number 21. That is the reply.
21 of?
21 of the last lookout, signed on 17/10/25.
21.
20.
What is the academic year with which you are concerned?
I have qualified in the year 2014, but recognition has been granted. Every year recognition is not granted.
That's right.
2008 में recognition मिला और उसके बाद 15 में revision हुआ, and that letter they are annexing and they have written very clearly.
Read it please.
ये revision. वर्ष 12, 13, 13, 14 की अवधि के राष्ट्रीय अध्यापक शिक्षा परिषद द्वारा मान्यता संबंधी प्रमाण उपलब्ध कराने के बाद पत्रांक अपना सिमडेगा दिनांक 8/10/25 माननीय उच्च न्यायालय झारखंड रांची में लंबित अनुवाद संख्या 631/24 महोदय उपरोक्त विषय में देख के आपके पत्रांक क्रमांक 1209 कार्यालय जिला शिक्षा अधिकारी द्वारा मांगी गई वर्ष 12, 13 एवं 13, 14 की अवधि की अनुमति के प्रति दी जा रही है एवं अन्य जानकारी का विवरण निम्न प्रकार है। राष्ट्रीय अध्यापक शिक्षा परिषद द्वारा मान्यता सिर्फ प्रथम वर्ष ही दी जाती है। राष्ट्रीय अध्यापक शिक्षा परिषद द्वारा जेके जैन मेमोरियल कॉलेज ऑफ एजुकेशन को प्रथम वर्ष 100 सीट की मान्यता दिनांक 14/8/2008 को दी गई थी प्रति संख्या। राष्ट्रीय अध्यापक शिक्षा परिषद दिनांक 30/5/2015 को बीएड कोर्स में 100 सीट को एनसीटी द्वारा 50-50 में विभाजित कर 2 इकाई बना दी गई। एंड दिस लेटर वी हैव आल्सो ब्रॉट अ रिकॉर्ड
आगे पढ़िए नेक्स्ट।
दी गई। जेके जैन मेमोरियल कॉलेज ऑफ एजुकेशन का अंतिम प्रवेश सत्र 2017 रहा है, जिसमें अध्ययन विद्यार्थी वर्ष 2019 में उपाधि पूर्ण कर चुके हैं। एंड देयर आफ्टर दे हैव अनेक्डोट्स टू लेटर्स।
उसके बाद इनका यहाँ एडमिशन नहीं हुआ।
वही तो मैडम,
अंतिम प्रवेश सत्र 2017 जेके जैन मेमोरियल कॉलेज का।
my supposed see the letter annexure C also. We have also written them. You have provided us the detail, but not specifically to that particular year which we are asking.
Which particular year?
Whether in 2012, 13 or 13 to 14 academic year, it has been recognized or not.
It is very much there.
Yes, it is there.
Just unable to understand DSC. I don't understand how.
They say that it is recognized only in the first year. Recognition is given only in the first year. There is no concept of renewal of recognition.
उस लेटर जो हम लोग लाए थे ये लेटर से उसको एक बार वेरीफाई करना था कि वेटर डायरेक्टर इज जेन्युइन और नॉट। सो दे आर सेइंग दैट इज अ जेन्युइन लेटर बिकॉज़ दे डिडंट ब्रिंग इट ऑन रिकॉर्ड। आई डोंट नो।
My letter may also be seen. Let's see. Just page 25. This is 21 and next 25. So what is my?
ये दे तो रहे हैं कि एक ही बार होता है, 2008 में हुआ है, और क्या चाहिए आपको?
एक बार पार्टी में
नहीं, जबरदस्ती क्या पार्टी बना देंगे कंटेंट?
हम फिर सप्लाई फोकस फायर करते हैं लॉर्ड।
It is very clear.
हाँ, it's very clear.
पूरे इंडिया में ऐसा होता है, मात्र यहाँ पे। How DSC is not understanding?
अब यहाँ पे भोपाल के लोगों को कंटेंट में डाल दें, कोई मतलब है इसका? Contempt Civil 631 of 2024. The letter dated 13/10/25 has been placed by the Learned Counsel for the petitioner, which is enclosure to the show cause dated 16/10/25, filed by the District Education Officer Simdega. He submits that the said letter is very clear. And it has been clearly mentioned therein that recognition is given only in the first year, which was given on 14/8/2008, and the last academic year in the in RKDF University was in the year 2017.
JK Jain Memorial College.
That's okay. JK Jain Memorial College was in the year 2017, ending in the year 2019. Counsel for the opposite party seeks adjournment to file supplementary show cause. On with respect to the compliance of the order of this court. इसको रीड से मोटा मत बनाना। आदमी पसंद नहीं आ रहा आपको? मिल नहीं रहा आपसे? ठीक से शेखर नहीं हो रहा? क्या करते हैं आप?
अब सारा सोनी कुमारी से रिलेटेड है ये मेडिसिन के केस, सारा प्रक्रिया कंप्लीट हो गया है। एक शॉर्ट डेट को वेरी लॉन्ग इट इज गोइंग ऑन।
5th December.
Item 29, Contempt Civil 755 of 2024.
Yes, the revision of the order was in 2 parts. Reinstatement and arbitrages. Reinstatement has been compliant, and the second aspect of revision, the amount that has been given as per instructions, that is not the entire amount. They bring on record the computation as to what will be the
Computation, you see, you can raise a point of computation with them directly. We are not going to
submit for revision. What are the pointers that has not been paid to the petitioner?
Okay, but you will raise a grievance before them.
If the leadership may kindly consider that is full compliance, the leadership may kindly consider that.
But even if otherwise, if they are agreed with the computation, they can always move before.
You see, we have just said 25% back wages.
And
We do not know in content jurisdiction as to what would be the component of back wages which you are entitled. That will be governed by your service conditions.
And apart from the computation, there is one more thing in addition. With submit. In addition, the order was to reinstate with continuity and 25% back wages within 3 months. In addition, they have paid the back wages from the date of dismissal till last month, that is September 2025. But in my submission in leadership, as per leadership's order, from the date when the impugned orders were quashed and when reinstatement was ordered, until last month, that is September 25, for the period of this 1 year. Because what was payable was the entire pay in view of the fact that he was to be reinstated, and there was no stay at any point in the SBA. So it's despite there being a reinstatement order, he was not reinstated. So for this 1 year, it's to be paid the entire payment and not 25%.
Till the date of reinstatement.
Yes, from your leadership's order until September 2025 for this 1 year. From April 22 till the order passed at WBS 25% back wages, and from the order passed at WBS till September 25 for this 1 year when he was to be reinstated. There was no stay in the FBA. Well, he was to be paid the entire pay in lieu of reinstatement.
That's not planned, so here he can file a separate petition. If
That
he
is a
has
separate,
agreed.
you see, there are so many jurisprudence which will enter into it. Right? It is not so straightforward. If you have any grievance with regard to wages, back wages, with regard to period or quantum, you can raise a grievance before
The special leave quarterly bonus and yearly bonus have not.
I will not say anything. It will be paid to you as per your terms and conditions of employment.
If they may consider at least.
Not in contempt jurisdiction. Contempt case civil number 755 of 2024, counsel for the parties are present. The learned counsel for the petitioner has submitted that the petitioner has been reinstated but belatedly. He has also submitted that he is entitled for back wages till the date of reinstatement.
Back wages until the order passed in writ petition, and from that when
Back wages until the order passed in writ petition, that is till 8/4/2024, and full wages thereafter.
3 months
When
from
full wage thereafter during the period when the order of the writ court was not complied. Only 3 months' time was granted to the opposite party to comply the order in the writ court. Counsel for the opposite party has opposed the prayer and has submitted that the petition has been reinstated on 18/10/2025 with continuity of service.
Yes.
18/10/25.
Only back wages, not shift.
Just a moment. With continuity of service, if the petitioner has any grievance in connection with back wages or any monetary benefit, he may raise his grievance as may be permissible under law, but so far as the present proceedings are concerned, the order of this court has been complied. Considering the aforesaid submission, this court is not inclined to enter into the dispute with regard to the quantum and the period of wages/back wages. Accordingly, this court is not inclined to proceed any further in this contempt proceedings, which is hereby dropped. However, if the petitioner has any grievance in connection with quantum of wages/back wages, which has been paid to the petitioner, he shall raise his grievance as may be permissible under law.
Item 31, contempt civil 466 of 2025.
Yes.
supplementary so-calls in terms of last.
LP has been dismissed. Allow me.
Lordship have passed the order on the basis of the LP orders. They have passed the order, notice of promotion has been given to 276 FL.
Time.
But because the senior is not here, he was assisting the board. My lord, he is not in the.
Who is
Mr. Mixing CG.
contempt civil 466 of 25 at the request of the counsel for the opposite party holds this case on 9th of January. 9th January 26.
Only not to.
When you pray for not today, I will give date as per my words.
Item 33, contempt civil 679 of 2025.
It has been mentioned that the amount has to be quantified, which was already there.
They have quantified.
No, they have quantified it. They have given a show cause. It has been mentioned that 9,20,785. This was at the time of pendency of the writ petition. Also, this amount was there. And the order further says that if there is no legal impediment, the said amount be disbursed to the petitioner upon being satisfied with regard to entitlement. And then the speaking order says there is no dispute to my entitlement. And they have mentioned that this is the amount. This amount to writ petition जब फाइल हुआ था आपके ऑर्डर में annexure 3 आपने लिखा है पैरा 8 में. उस समय भी यही चीज था, यही अमाउंट देना था आपको उसी ऑर्डर के in accordance with ये ऑर्डर पास हुआ. आप उसी चीज को लेटर नंबर डेट नंबर चेंज करके फिर वही ऑफिस ऑर्डर कार्यालय आदेश निकाल दे रहे हैं कि हमको इतना बन रहा है. इतना तो बन ही रहा था उस समय भी रीड कोर्ट के टाइम में.
Yes, what is it?
As per our supplementary show.
So let us see the order.
Yes, order is that page number 13. Para 8.
Yes, it was already quantified. Way back on 13/6/2017.
In our show cause we have stated that fund आने का है, fund आ जाएगा, we will release.
तो जमीन क्यों ले लिए? नहीं लेना था ना? You should have waited. 2017 say you don't have fund and you have taken the land from them. Why did you take the land? The state has gone bankrupt. कितना 9,20,000 आपके पास पैसा नहीं है? लैंड एक्विजिशन के समय पूरा पैसा जमा होता है कि नहीं होता? Then क्या है ये? Who is he? Has he said that he does not have money? Then I'll ask the chief secretary to file a response here. क्या चीज के लिए 2 weeks? आप पैसा जमा करा दीजिए यहाँ पर. फिर हम आपको 2 weeks नहीं 20 years टाइम देंगे. जमा करा दीजिए यहाँ पैसे. What is this? Where have you stated that you don't have funds?
Supplementary. Page 6 of my supplementary show.
Please, what have you stated?
Reason order has already been passed.
क्या करें उस reason order का? Is it worth eating? Can you reason order buy even a pin from the market? पढ़ी आगे. पैसा नहीं है दिखाइए हमें.
In order to comply honorable court order, the answering respondent party number 4, executive engineer RW Kuji has taken necessary steps in this regard and letter number 29/10/2025 addressing to the deputy secretary rural work department communicated to provide the necessary funds in this regard and as per the direction given by the leasing act for payment of compensation to federation. Next paragraph.
Just a moment. Communicated this letter. This is 29/10/25. Page number 15. he has written it to the Under Secretary, Rural Development Department. So where is the role of Deputy Commissioner here?
On instruction, in para 8, we have specifically stated that as a fund will be made available, the compensation amount with regard to the land in question will be given to the petitioners.
The Deputy Commissioner has also given a direction for payment. This statement made para 7, I am not able to understand. पूरा एक पन्ना का एक sentence है. One sentence in one page. Please break it for me. Break the sentence for me. What is the role of Deputy Commissioner in this payment?
Annexure A में phase 13 में देखा गया.
Annexure A, that reason order was passed by police.
He is the Under Secretary, Vijay Kumar Bhagat. Up Secretary is Deputy Secretary. Deputy Secretary.
Ramin Khan.
आप उनको पार्टी बना दीजिए. You seek instructions from the Secretary of the Rural Development Department, Rural Works Department. Content 7679 of 25. As per the supplementary show cause, dated 30/10/25, a letter has been placed on record dated 29/10/25, issued by the Executive Engineer, Rural Works Department, Work Division, Khunti, to the Deputy Secretary, Rural Works Department, Government of Jharkhand, Ranchi, asking for fund of rupees 920,785 for payment of compensation for acquisition of land. Is it for acquisition of land?
ये acquisition तो हो चुका है already, पैसा नहीं. Compensation, monetary compensation.
Monetary compensation relating to land, for which the amount was quantified way back on 13/6/2017, followed by the order passed by this court dated 12/11/2024, which was further followed by a recent order passed by the Deputy Commissioner dated 29/10/2025, confirming the entitlement of the petitioner. इंटरेस्ट के बारे में कहा?
कैपिटल अमाउंट पर कहें कि कैपिटल अमाउंट क्या है.
The petitioner is directed to implead the Secretary, Rural Works Department, Government of Jharkhand, Ranchi, as opposite party number
5.
number 5, and the Council for the State is directed to seek instructions and file a supplementary show cause. इंटरेस्ट के लिए आपको अलग से लगना होगा।
कैपिटल ही दे देना, बात खत्म हो जाएगी। वो इतना भी तो दे
आपको
देना।
लग रहा बात खत्म हो जाएगी 2017 से।
66 years की वो
2017 से
लिटिगेशन लगते लगते वो कैपिटल भी उनको मिल जाएगा, वो कहेंगे कंटेंट ड्रॉप कर देंगे, हमको पैसा मिल जाएगा, हम अपना शांति से कर लेंगे। लेकिन उनको तो ये भी नहीं मिल रहा, और उनको 66 years के बच्चे हैं, सब लोग परेशान हो रहे हैं। 17 में ही ऑफिस ऑर्डर निकला था, कितना पैसा मिलेगा? वो ऑफिस ऑर्डर आप रीट में मैंने लगाया था, आपने
I'll give you the liberty to raise for the claim of interest later on. पहले तो ये 9 लाख रुपए आप ले। अगला डेट में नहीं डिस्बर्स किए ना तो पैसा यहीं से नहीं जमा करवाएंगे, या फिर डायरेक्शन देंगे कि इनका लैंड आप रिलीज कर दो। यही हो सकता है ना? आपका इंस्ट्रक्शन लिखा है? लिखा है? यहाँ जमा कराइए, आपके पास नहीं जाएगा ये पैसा। नहीं, झारखंड में नहीं भेजेंगे हम कहीं पर। यहाँ से ऑर्डर हो गया है, पैसा यहाँ जमा कराइए या इनके अकाउंट में ट्रांसफर करिए। नहीं, कोई मतलब ही नहीं है, कहीं जाने का कोई जरूरत नहीं, यहाँ जमा कराइए। किसके नाम से पैसा मिलना है? आप नेक्स्ट वीक में एफिडेविट फाइल करें। She will not go. I'm telling you, she will not go to your office to take money. If the amount has already been received, नहीं छोड़ दीजिए आप, नेक्स्ट वीक करिए। I do not know. आपका ये इंस्ट्रक्शन का कोई वैल्यू नहीं है ऑर्डर लिखाने का। 21st को पोस्ट कर उनका एफिडेविट फाइल कर दीजिए that amount has already been received और डिस्बर्स कर दीजिए, एकदम पैसा इनको अकाउंट में डिस्बर्स कर दीजिए।
एनेक्सर 2 जो है पेज नंबर 14 में कंटेंट पेटिशन में मैंने लगाया कि जॉइंट अकाउंट है,
अकाउंट का डिटेल दिया हुआ?
सब दिया हुआ है,
सब दिया।
प्रेजेंटेशन नहीं लगा हुआ है।
चलिए नेक्स्ट
Item 34 contains 745
ये सब चीज में थोड़ा सा खुद एक्टिव होके यू शुड टेक स्टेप्स, isn't it?
बहुत तकलीफ भी होता है, ऐसे लोगों को पैसा नहीं मिलता है।
25 साल हो रहे हैं झारखंड, ऐसा महसूस नहीं हो रहा। पैसा लेने के लिए हमको पता चला है, जो यहाँ से ऑर्डर होने के बाद पैसा लेने के लिए जाते हैं उसमें भी गड़बड़ करते हैं। क्या गड़बड़ करते हैं तो हम तो क्या ही बोलें, आपको ज़्यादा पता होगा। Even basic things is not being smoothly disbursed to the persons. चलिए नेक्स्ट नाम बताइए, आपको क्या बोलना है? Which serial number is this? Next yes.
This
बताइए।
I was to file a receipt such a recently, even as a contact one in Bharata. So then I contact one will file I 2 weeks or
When did he die? आपका हो गया compliance?
compliance नहीं हुआ. I'm checking last time. Complicated to be last time.
Council for the parties jointly pray for adjournment. Post on 9th of January. आप देख लीजिए क्या करना है, आप अपना सब्सक्रिप्शन करिए।
Item 35 contains 784 of 2025.
What is it?
Supposed to refer the matter to the Nagaland civil court for
क्या हुआ?
Earlier they have stated that the matter was referred. The person had called for the report, it was not there. They have stated that the matter was returned back by the civil court.
Turn back का क्या ही?
उसका कोई अभी तक नहीं रिकॉर्ड ना ये एक एनेक्सर भी लगा है, they have stated noting with the master court staff of the civil court.
Only 7 of them dated
ये क्या है, क्या चीज का पार्ट है?
The exception fee, that is the defect. Where is the defect?
Decision dated 1999-2024. That is mixer case.
No, I want to know that you were directed to place some record, no, to show that it was returned.
That is an exception. Page 6, para 11, if you not see. The so-called dated filed on, we received on 30th October and 29th of 30th October. Last affidavit. Page 6, para 11.
क्या है?
ये यही डॉक्यूमेंट है, ये डिफेक्ट था जो पॉइंट आउट था इसके चलते लौटा।
ये सिविल कोर्ट के स्टाफ को जुरिस्डिक्शन है डिफेक्ट फाइंड आउट करने का? कहाँ से इनको जुरिस्डिक्शन है?
एक्ट में है,
एक्ट का छोड़िए, सिविल कोर्ट के किसी भी स्टाफ को फिर क्या है? और कौन स्टाफ है जो ये क्या नाम है इसका?
सेक्शन 64 में रेफरेंस टू सिटी ऑथोरिटी में से सेक्शन 65 कलेक्टर स्टेटमेंट टू ऑथोरिटी इन मेकिंग द रेफरेंस द कलेक्टर स्टेट द इंफॉर्मेशन टू द ऑथोरिटी इन राइटिंग अंडर है क्या चीज भेजना और वो चीज का मांग रहे नहीं।
हम आपसे ये पूछ रहे हैं कि कौन है सिविल कोर्ट का ये स्टाफ? सिविल कोर्ट के स्टाफ को क्या जुरिस्डिक्शन? ही जस्ट अ पोस्ट ऑफिस।
हाथ से कोई कुछ लिख दिया अपने से।
सिविल कोर्ट का स्टाफ इज जस्ट अ पोस्ट ऑफिस, isn't it? So far as these, the case record has to be scrutinized by the appropriate person.
After acceptance of filing,
there could be many objections. आपके काउंटर में रिट पिटीशन ऐसे डिटेक्ट करके फेंक देते क्या कि लेकर उस पे डिफेक्ट निकाल
फाइलिंग नंबर पड़ता है उसके बाद डिफेक्ट होता है।
इनको पुट अप करना चाहिए ना, आप डिजाइनिंग से रिजेक्टेड अगर डिफेक्ट था और लिबर्टी देना चाहिए था, लेकिन ये वांटिंग मांगा है कि नहीं है आप मैच्योर कर दीजिए।
कौन है ये स्टाफ?
वेरीफाई कर दीजिए, उनका डिपार्टमेंट का किसी का हो।
कौन है ये स्टाफ?
वेरीफाई कर चुके हैं।
नहीं
नहीं जैसे आप एफिडेविट क्या करेंगे? आप तो बहुत एफिडेविट के मास्टर हैं।
नहीं आप मास्टर नहीं, आपका
मास्टर है,
गलत इल्जाम मत दीजिए।
आप गलत इल्जाम नहीं लगा रहे हैं, तो रिकॉर्ड में वही बोल रहा है।
नहीं
आप उसको देखिए हुजूर, पुराना काउंटर बढ़ जाए।
ऑर्डर
आई एम जस्ट why I am saying so, I will just demonstrate. I don't say anything beyond the record.
Order number 5
I am not in habit of saying so.
नहीं, order number 5 for dated 4/5
the first counter video.
हमको याद है, आप चिंता नहीं करें।
पैरा नंबर
It has been recorded by this
Among highly such respondent of 3 directed to look into the demands of the prisoner and also grant the opportunity of hearing to the prisoner who cover the notice and issue and pass appropriate order in accordance with the applicable law, so that demands of the prisoner is addressed. The region's order be communicated to prisoner through speed post and at the address to provided by the prisoner in his representative. ऐसा मत बोलिए सर कि हम गलत बोलते हैं, हम ऐसा मत बोल रहे हैं।
आपको नहीं बोल रहे हैं, आपके क्लाइंट को बोल रहे हैं।
आप ठीक है, क्लाइंट को बोलिए जो बोलना है,
आपको क्लाइंट को बोल रहे हैं, आपको नहीं।
आपने यहाँ पे बोला कि ऑलरेडी क्या पहले बोला था कि ऑलरेडी
yes, you know, just see the first counter affidavit where he has categorically stated that paragraph 8 that it is stated that the district land acquisition officer Ranchi issued white letter number such and such has referred the dispute to the civil court, that is para 8 page 6 of the earlier counter. That has been recorded by your lordship in the
उसके बाद we took a
report was called for.
We took a report.
Report has been received.
Report has been received.
That is
right. Report has been received that it had never come.
Yes.
Report is that it was never come. ना उसे वहाँ पे क्लर्क से क्या क्या लिखा है? कौन सिविल कोर्ट का क्लर्क लिख के दिया? बताइए ना भाई, सिविल कोर्ट का क्लर्क तो हमारे जुरिस्डिक्शन का चीज है ना। We will take care of him. We will take care of him. उसके लिए कहाँ कौन है वो? नाम बताइए, नाम बताइए कौन है? किसी को प्रोटेक्ट करने की कोशिश मत करिए। आपने क्लर्क का नाम क्यों नहीं लिखा? Why have you not written? उसी क्लर्क से हम एफिडेविट मांगेंगे, आपको क्या लगता
पैरा
है?
11 में लिखा है
जिसका नाम लीजिएगा उसी क्लर्क से एफिडेविट मांगेंगे टू ओन और डिसोन. कोर्ट में झूठ नहीं चलेगा.
Just let me elaborate place the affidavit. Therefore, the deponent is also seeking unconditional apology. The para 4, the present content arises of the Honorable Court Order 4/5/2023, passed in WPC number 3812 of 2022, passed by the Honorable Court, the Authority Power. Then again, that very also the deponent Minister some persons to the order dated 4/5/2023, passed in WPC number. These and that is after the hearing the party and considering documents came to the conclusion and passed an order on 19/97/24 for referring the dispute to the Civil Competition Court as the matter relates to dispute of land. That the very of the given ministers that order been complied with and matter has been referred to the Civil Competition Court. They can earlier get the supplementary so-called affidavit has been filed duly sworn by the deponent. I was number 557/0/19/2025. The only status and the thereafter matter was taken up 26/9/2025. And the Honorable Court has passed the order granting time to file supplementary so-called relative to correcting of the supplementary so-called affidavit and posted the matter on 31/10/2025. That an earlier affidavit has been stated that the office of the police partner has referred the dispute to Civil Court Ranchi and also sent the record of the Civil Court Ranchi bearing letter number 1347/23/9/2024. But the same was returned to the office of the Civil Court due to some defects in the defense. That after clearing the defect, the record has been sent to the Civil Court Ranchi, which has been received on 18/8/2025. The only statements on the earlier the staff of Civil Court had pointed out the defects on the rough paper and returned the record to send it after getting it corrected. The deponent only states that the whole party had agreed for maintaining the majesty of the Honorable Court and otherwise abiding by the order of the court or any court of law resources.
आपका नाम बताइए.
Name of the staff.
बता दीजिए ना. आपका तो रोज कहाँ आ जाना है सिविल कोर्ट. स्टाफ का नाम आप बताइए. नाम एफिडेविट में बताइए.
Without affidavit, I cannot.
Certainly, you file an affidavit. Who is that staff?
I cannot say this. Because the opponent is here himself. He can say.
He will say. He has to say.
Section note means plot 434 note record name of Vijay Pahan note match with name deposit in amount equated bank details कुछ लोग BC हैं क्या लिखा हुआ उनका नाम lower application जो file किया objection but not signed this has also been written in the sign. Situation is this.
2017 में मुझे मेरा जमीन मिल गया. I am old lady retired person. बनारस हिंदू यूनिवर्सिटी में हेड ऑफ द डिपार्टमेंट के जो बुजुर्ग का ऑर्डर होने के बाद भी
लेना चाहिए उसमें
एक साल और
ये पार्टिकुलर्स होना चाहिए क्योंकि सेक्शन 65 में रेफरेंस के बाद लिखा हुआ कलेक्टर्स स्टेटमेंट टू द हॉस्पिटल
डेट और कौन
तो ये ऑब्जेक्शन कौन निकालेगा? इंस्टीट्यूट होगा, डिफेक्ट निकलेगा, उसको रेक्टिफाई
हां
किया
उसका
जाएगा.
स्टाम्प रिपोर्ट होने के बाद नहीं होना चाहिए.
तो ये क्या है?
ये तो कच्चा चीटिंग है इसी का रफ पेपर
किसी का सिग्नेचर डेट कहीं नहीं.
कुछ नहीं.
हां वो तो दैट पॉइंट आई एम नॉट.
तो इनका जो ये जो इतना डिले हो गया है इसको कौन कॉम्पनसेट करेगा? You were seeking enhancement of compensation.
Yes. No objection against the award. Award was wrongly declared, therefore you receive
interpret
the matter. Yes, I am saying the same thing. Objection with regard to the award
the amount of
private respondents and claim respondents.
देखिए उपाय भी मैं आपको बताऊं. एक सच्चा एफिडेविट फाइल करिए, झूठा बात नहीं. एक सच्चा एफिडेविट फाइल करिए कि ऑर्डर हुआ था and due to some gap this affidavit was filed and this was found in the record. जो भी कौन लिखा है नहीं लिखा है क्या है we do not know. लेकिन ये जो बोल रहे हैं ना कि सिविल कोर्ट का स्टाफ वापस कर दिया, ये सही है।
क्या बोले लेकिन वास्तविकता जो है जो मैंने पूछा यही था। वास्तविकता जो हमने पूछा कि ये आप
इसको आप सब्सटैंशिएट नहीं कर पाइएगा और कभी नहीं।
हाँ नहीं कर पाए
आप अपना एक प्रॉपर एफिडेविट फाइल करिए कि कुछ गैप हो गया अल्टीमेटली, एंड देन वी आर नॉट इंटरेस्टेड इन प्रोसीडिंग अगेंस्ट एनीबॉडी। लेकिन झूठा एफिडेविट से हम लोग को बहुत एलर्जी है। हाँ, लोग कहते हैं कोर्ट में एक गलती को ठीक करने के लिए आदमी 50 गलती करता है, उससे ज्यादा अच्छा है कि उसी गलती को सुधार लिया। इतना खाली बोलना है कि भाई रिकॉर्ड में ऑर्डर था तो हम ऐसा लिख दिए।
जो डिस्ट्रिक्ट लैंड एक्विजिशन अफसर हैं, सीओ के हैसियत से कितने का पैसा खाया वो रिकॉर्ड मीडिया में आया, वो हमने उसका आउट ऑफ रिकॉर्ड।
देखिए मिस्टर साहनी को जल्दी गुस्सा नहीं आता।
हम कभी गुस्सा से नहीं,
अब गुस्सा कर रहे हैं तो बहुत ग्राउंड वर्क होगा गुस्सा करने के लिए।
जो बात हम उसको क्या बोले, हम
आप एफिडेविट फाइल करिए, हम सिंपलिसिटी प्रॉपर एफिडेविट फाइल कर दीजिए, ठीक है, कि इसको जो है आप यू आर नॉट इन अ पोजीशन टू substantiate as to when this was sent and what exactly happened, because this is being handled by the office, right? This is being handled by the office, and now the matter has already been referred. अब तो चला गया, केस इंस्टीट्यूट हो गया।
चला गया, मुझे बोले 2 दिन के 1 लाख का कॉम्पेंसेशन देगी, जो क्षति पहुंची 4 साल।
कॉम्पेंसेशन तो इनको इंटरेस्ट के साथ ही ना मिलेगा, जब भी मिलेगा आपको, जब भी मिलेगा इंटरेस्ट के साथ।
ये अपने पास रख दिए
इंटरेस्ट के साथ, इंटरेस्ट का प्रावधान है।
8 बार बहस सुन के
जवाब नहीं मिला,
उसके बाद जो भेजे हैं बोलते हैं कोर्ट को भी धोखा देते हैं।
इनको एक झूठ मत बोलिएगा, इस बार झूठ मत बोलिएगा।
नहीं मुझे झूठ नहीं बोलेंगे हम। इस तरह का बिल आया वन फिल दूंगा या नहीं का था, मेरे पास आया था, उन्होंने रिजेक्ट कर दिया था प्रिजाइडिंग ने, डिफेक्ट था, प्रिजाइडिंग ने रिजेक्ट कर दिया था। ये अब ये अगर वास्तविक बात थी तो इनको प्लेस करके रिजेक्ट कर देना चाहिए।
शुड हैव बीन प्लेस्ड।
हां रिजेक्टेड।
अभी तो आपके पास कोई मतलब इनफैक्ट आपके पास कोई डॉक्यूमेंट नहीं है कि आपने कोई चिट्ठी, आप कोई रिकॉर्ड भेजेंगे तो बिना चिट्ठी के भेज देंगे। चिट्ठी कहाँ है?
वही चिट्ठी तो चिट्ठी के साथ गया 23/24।
चिट्ठी कहाँ है?
जो बाद में रिसीव हुआ 18 लेटर गया।
हाँ वो बाद में रिसीव हुआ। तो आप बताएंगे ना भाई कि ये चिट्ठी हमारे पास पड़ा रह गया, नहीं गया।
24 में चिट्ठी गया, उसको कोई रिसीव नहीं किया। 25 वाला चिट्ठी रिसीव हुआ।
अब वो 25 में रिसीव नहीं है ना आपके पास, ना रिसीविंग है ना कुछ
ऑन रिकॉर्ड नहीं।
ऑन रिकॉर्ड में चिट्ठी लगा हुआ है तो क्या करें हम?
लेकिन वो कहते हैं कि गया था वहां से।
कहां से हाउ डज इट पर्सन गेट दिस इंफॉर्मेशन?
तो जो वेरीफाई करते हैं
झूठ नहीं, देखिए रिकॉर्ड में झूठ मत बोलिए। आई जस्ट डोंट लाइक
हम नहीं झूठ बोलते, हम तो पर्सनली एज ए लॉ ऑफिसर हम नहीं बोलते हैं। अब
अपने लिटिगेंट को भी झूठ मत बोलिए।
हां ठीक है,
क्लास उनका चेंबर में लगा।
आप क्लास लगाए और लड़का को बुला देते हैं। क्लास स्वामी है,
कब रख दे बताइए रांची का है ना मैटर?
हां रांची
अगला हफ्ता रख दें, 28 को रख दें,
28 को नहीं, 28 से 8 तक
5 तारीख को रख दें। 28 से 8 नहीं है?
हां नहीं,
कहाँ चले जा रहे हैं? 12 तारीख। Counsel for the opposite party has submitted that he shall file an appropriate show cause explaining the position. However, from the records, he is unable to substantiate that the matter was actually placed or sent to the court earlier. Okay? At his request, posed this case on 20th of December. The supplementary show cause be filed latest by 10th of December. 12 तारीख को रखना है, 10 तारीख को 12 को रखना है, आप फाइल कर दीजिए 10 तारीख को।
Password case item 23, contention 915 of 2023.
What is the date? 20/11 कितने बजे? 11 AM। The date has already been.
Date has been fixed, but time has not been defined.
बताइए कितना बजे बता दें? 11 बजे बोलते हैं?
Yes.
Letter has been issued to them.
Later, notices have been issued.
Content Civil 915 of 2023. The Council for the Opposite Party State has submitted that on earlier occasion when a date was fixed for measurement or demarcation, the needful could not be done on account of heavy rains. Now a fresh date for appearance has been fixed on 24/11. 2011, 2025. However, any particular time has not been fixed. She submits that it would be better if the parties appear on 11, at 11 a.m. Sir, you are also there? Considering the aforesaid submissions, let the demarcation be done on the scheduled date, that is on 20/11/25, and the parties to appear and the concerned parties to appear on 11 a.m. इनके अलावा भी कोई पार्टी है क्या? नहीं, हम ऐसा नहीं करेंगे. 11 a.m. का टाइम नहीं दे सकते. ऐसा टाइम नहीं दे सकते. नोटिस आपने दिया लेकिन टाइम नहीं दिया. सब अलग अलग टाइम पे आएंगे. देना चाहिए ना टाइम.
क्योंकि जो सॉफ्ट कॉपी दैट हैज बीन प्रोवाइडेड उसमें टाइम मेंशन नहीं है. So I could not get the printout.
खाली इतना ही लिखिएगा. Notice has been issued for demarcation on 20/11/25. हम टाइम नहीं दे सकते यहाँ से. आप लेकिन टाइम दे दीजिए. There has to be a time. Council for the Opposite Party State has submitted that an appropriate time for appearance on 20/11/25 will also be communicated to the concerned parties.
IA is also on board with this for granted further board extension is filed on 17th.
IA number?
IA number 14540.
14540, seeking extension of time.
4 weeks time.
तो हो गया 4 weeks.
2 दिन में हो जाएगा.
Extension of time is closed as the period seeking extension is already over. कब करते हैं? 20/11. 12th of December.
Item 36, CMP 808 of 2025.
Notice was issued on 26/9/2025. Requisite was filed on 6/10/2025 number, and it was delivered to the sole respondent on 15/10/2025. Trial report is there.
Why was it dismissed?
Council have given paragraph 678. I have got some prior
कोई ऑर्डर नहीं लगाते हैं किस ऑर्डर से डिसमिस हुआ है पिटीशन.
9th July 2020.
देखिए CAP number 808 of 25. Counsel for the petitioner is present. Nobody has entered appearance in spite of service of notice. This petition petition has been filed for restoration of first appeal number 181 of 23. It was dismissed for non-prosecution on 9/7/25. Counsel for the appellant has submitted that on account of personal difficulty, the counsel for the appellant in first appeal could not appear on 9th of July 2025. Considering the submissions and being satisfied with the cause shown, first appeal number 181 of 23 is restored to its original file. And the order dismissing the first appeal dated 9th of July 25 is provided. Office is directed to place the first appeal. May this CNP is accordingly allowed. Office is directed to place the first appeal in the next day. उनसे पूछ लीजिएगा ना, उनका वकालतनामा उसमें फाइल इंस्ट्रक्शन ले लेंगे वो। अदर साइड पे अपीयर हो गए थे ना, फिर भी अब तो रिस्टोर हो गया है तो अब फिर से नोटिस देना पड़ेगा ना। फर्स्ट अपील में फिर से नोटिस देना पड़ेगा क्योंकि केस तो डिसमिस हो गया। आप याद रखिएगा इस चीज़ को। बिना फ्रेश नोटिस किए अगर केस डिसाइड हो जाएगा आपके फेवर में, then the order will become defective.
If you will not protect
He will agree. He is a very decent counsel. क्या नाम है उनका, नाम भूल गए, उनको याद है।
Item 37, contemptible 873 of 2025.
The state has filed with the Ministry of Lordship, stating that the HRD department has approved the pay fixation.
So your grievance is redressed?
No, Your Lordship. Till today, the payment has not been made, Your Lordship, by the university. And kindly have a look to the page number 11, Your Lordship, what they have done. Fifth column, Your Lordship, date of absorption and confirmation. Initial date of joining, Your Lordship, 3/12/1993.
That is not the scope of the order.
Lordship, university has forwarded the fixation of Your Lordship, the chart of the fixation, Lordship. University has also filed a counter, Your Lordship. Kindly have a look. There is an anomaly, Your Lordship. Last column, Your Lordship. Revised pay in 7th scale as on 1/1/2016, Your Lordship. HRD has approved 19,100, Your Lordship. And university has filed, which has been forwarded by the university, Your Lordship. And that has been filed on 19/9/2025, Your Lordship. Kindly have a look at that, Your Lordship. Page number 8. University has forwarded, Your Lordship, 23,500, Your Lordship. They are accepting my joining absorption from the 2010, Your Lordship. Though she was appointed in a pay scale in the year 1993, Your Lordship. That's why these anomalies are there, Your Lordship.
But what is the nature of the order? You just see what is the nature of the order. You see, if you are, they have given you the relief, but you are not satisfied with the quantum of payment and also the date.
But payment has not been payment has not been made by the university, Your Lordship, in spite of the approval.
Admissible amount तो payment करेंगे ना?
making up payments, but the state has put a condition on the petition. If you see the page number 11 of the super funded state.
Again, they are doing
Where is the state council? What condition?
एडिशन में जस्ट सिंगल लाइन कि इनका वेतन निर्धारण इस शर्त पर किया जा रहा है कि वादी के पति की सेवा से संबंधित सेवा को उसकी छाया प्रति निदेशालय को उपलब्ध करा दी गई।
कहाँ से?
I'll have to verify this edition. It should not be there.
She is the widow.
Yes, edition.
आप अपना रिकॉर्ड वेरीफाई करिए। What is this?
लास्ट ऑर्डर में भी ये चीज बोला गया था कि I am not supposed to supply these documents which are not having with me, Your Lordship. Last order में specific
Always
order
put the copy on the edition. But verify this edition.
There is no question of asking the widow to provide the service book, copy of service book.
We'll ask them to revisit this.
The last order will be.
last order, I hardly have a look at the last order.
अभी पहले आप रिकमेंडेशन लेटर मांग रहे थे, फिर अपने हस्बैंड का अपॉइंटमेंट लेटर मांग रहे थे, अब आप सर्विस बुक मांग रहे हैं। This letter has been issued by whom? Asking for the service book.
This अभी वाला leadership order.
ये 10/10/25.
Yes, that has been issued by us.
Where is it mentioned that service book चाहिए?
The remarks.
Remarks last. Page number 11. Remarks.
एक ही बात है ना?
Leadership is to revisit.
बात तो एक ही है ना, पहले आप डेट अपॉइंटमेंट लेटर मांग रहे थे और ये सब मांग रहे थे और अब आप सर्विस बुक मांग रहे हैं। It's the same thing.
Leadership.
Does that make any difference?
Leadership earlier the documents were being sought for by the university. We had never asked her to produce an appointment letter.
But this is not possible.
We will do this away with leadership. एक week का time दे दिया है.
Content Civil 873 of 2025. Counsel for the petitioner has drawn the attention of this court to Annexation A dated 10/10/2025 and its enclosure, and has submitted that the revised pay fixation has been made of her husband, of the husband of the petitioner has been made subject to submission of
No. Petitioner, Your Lordship. They have been appointed on a compassionate basis.
of the petitioner has been made subject to submission of service book. The petitioner has retired way back in the year 1991.
Service book, they are asking for service book of the
Husband.
Of the husband, no.
Yes,
Service book of the husband of the petitioner,
yes, sir.
who has
Died in
died in 1991.
1991.
1991. The learned counsel submits that it is not possible for the petitioner to furnish the service book. Counsel for the state prays for adjournment and seek instructions to do away with such a condition which has been put through the letter dated 10/10/25.
This may also be verified, Your Lordship. They fixation also. University जो भेजा है,
क्वांटम नहीं कर सकते हम लोग डिसाइड, क्वांटम नहीं कर पाएंगे,
लेकिन ये डेट ऑफ एब्जॉर्प्शन
नहीं,
आफ्टर 17 इयर्स
नहीं कर पाएंगे। कंटेंट में ऑर्डर का जुरिस्डिक्शन नहीं है वैसे।
ओनली टू हरास द petitioner और 17 साल वाली एब्जॉर्प्शन मांग रहे हैं और वो भी कॉम्पैशनेट अपॉइंटमेंट में।
Post on 28 November.
At item 38, CMP 970/2025.
So that's to the cell of this is for non-compliance of two carbon. However, the is otherwise and time till below 2024.
CMP number 970 or 25.
In this county by raising objection that the ground that has been taken for restoration is of COVID-19 pandemic, one of the grounds. Though the period that was not of the pandemic.
Cost.
Since it has been filed, so it was neglected.
Not only that, not because my illness, not because at that time I had that accident was it, and is completely clear that due to my illness. Actually, 26 April as that accident.
Pandemic and illness दोनों
And illness.
ऐसा नहीं बोले COVID-19 हो गया.
So I said one of the reasons that
CMP number 970 of 25. This petition has been filed for restoration of WPS number 6831 of 25, which has been dismissed on account of non-removal of defects in terms of order DT 21/4/22. The Learned Counsel for the petition has submitted that due to pandemic situation and illness of the conducting advocate, the defects could not be removed in time. Counsel for the state has opposed the prayer and has submitted that has simply opposed the prayer. After hearing the counsel for the parties and being satisfied with the cause shown, the time for removal of defect in WPS number 6831 of 2018 is extended till 19th of December 25. This CMP is accordingly disposed of. If the defects in the petition is cured within the extended period, office is directed to place the petition before appropriate bench as follows. Order is still preemptive. Time से करेंगे.
Item 39, CMP 970 of 2025.
Read that. Non-prosecution. इसमें क्या करें? बताइए. इन्फेक्शस नहीं हो गया आपका केस?
इन्फेक्शस नहीं.
CMP number 973 of 25. Notice we issued to the opposite party number to the opposite parties for which requisites be filed through speed post. Office to track speed post delivery. Post this case on 9th of January 26.
Should we periods के लिए 1 week time रखेंगे?
1 week. Requisites के लिए 1 week.
Item 40, Contempt Civil 1012 of 2025.
May I please in this case, one IA have been filed for sitting time for 12 weeks.
12 weeks.
Yes.
एक साल की भी मांगी? हाँ? You need 12 weeks.
Arun, he is appearing some other. In this case, they have filed a so-called. My lord, we kindly have a look to the order. The respondents were directed, petitioner was directed to file representation and they were directed to consider and decide with respect to calculation of earning. And they have filed their so-called annexing the order, my lord. I am just placing before your lordship, my lord, how they have decided. Nothing is written, my lord. Kindly have a look to page 20 of the so-called.
21 भी है.
हाँ 21 में ही है ये 300 days they are saying कि we are entitled to collect. This was claimed by the petitioner. This was how they have come to this conclusion. They have not respected.
अब क्या calculation?
अब हमारा मान लीजिए हमारा केस है कि we have collected 306 days. How this 306 days it is assuming 300 days, it comes to 240 days. Thereafter, I have collected 322 days. They have reduced it to 243 days. No reason is given why they have reduced it to 243 days. Our case was only thing is suppose we have collected 322 days and we have availed some early. So after 322 they will reduce. What they are doing, they are reducing first and then to 300 and then reducing the leave we have taken. This was our contention before that. My lord has said that you calculate and give the reasons.
इसका थोड़ा आप अपना इसको चैलेंज कर लीजिए. इसको हमें कुछ करना है. Contempt Civil 1012 of 25.
नहीं बोलना सकते. They have not given reason why they have come to this conclusion that we are entitled for this. No reason has been given. No way they have said how this has this calculation. Or this was I have given the years where they have detected the discrepancy. They have given this calculation for only those years. Entire service period का भी नहीं. I retired in the year 9.
इस कोर्ट का ऑर्डर कौन सा है?
Order is at page number 21.
ये जो आपका फर्स्ट कॉलम है, उक्त अवधि तक छुट्टी लेखा में अंकित उपवर्जित अवकाश संचयन, ये सब में 300 days है.
Yes.
Although he was claiming more than 300 days. Okay, 300 days मान लिए. Okay. How did you reduce it to scale it down to less than 300? एक में तो 300 you have accepted. For some period you have accepted 300. Then why for other periods you have admitted less than 300?
That is on the basis of the records that were made available to
What
the
record?
department. No. The last page number 20 last 9 years stated अनुसार संदर्भित अभ्यावेदन के आलोक में प्रशासनिक विभाग द्वारा उपलब्ध कराई गई छुट्टी लेखा विवरणी के क्रम में अंकित अवधि हेतु विभाजित अवकाश सृजन गणना रिपोर्ट निर्धारित होगी।
ये दोनों ये 300 फिर क्या फिगर है?
300 leadership is that is the maximum amount of leave that can be encashed by the petitioner. It is stated in the order of the leadership.
This is the maximum possible.
Yes, leadership.
And this is the claim.
That is the claim leadership, and on the rightmost column is the number of days that we have found would be able to the petitioner.
कुछ नहीं अब आप अपना calculation
एक छोटा सा This is the maximum I can encash. This is not the maximum leave that will be granted. This can be encashed. So my submission is, suppose for 1 year I have earned 222 days, and then I have taken 25 days. So it will reduce from 322 to thereafter 25 days reduced, and it will be 297. So my submission, this was the what they are doing. They are reducing it first 300 days and then deducting 25 days. Therefore, they have not given that part. We have first reduced and then deducted. Simply they say this is the disabled 300 and now this is the
Content case serial number 1012 of 25. The learned counsel for the parties are present. The learned counsel for the opposite party has submitted that a reason order has been passed. Counsel for the petition has submitted that it is not clear from the reason order as to how the opposite party has arrived at the calculation of the earned pay, earned leave. He submits that the counsel for the opposite party is directed to file a supplementary affidavit giving the calculation. Post on 28th.
Okay.
Item 41, content civil 1119 of 2025.
We are in process of compliance. So sometimes we can.
IA is not on board.
IA replied your lordship on 30/10/2025.
September
IA number 14549.
14549. It was filed yesterday.
File on your lordship 30/10/2025.
इसका फाइलिंग दिख रहा है रिकॉर्ड को नहीं. How much time do you need?
12 weeks.
12 weeks.
University concerns some post retirement may become matter because of this. Some more time. 6-9
retiring there.
Then we are in process. For compliance.
Content civil number 1119 of 25. Counsel for the opposite party has submitted that IA number 14549 of 25 has been filed, seeking extension of, or filed on 30/10/25 seeking extension of 12 weeks. He has submitted that the compliances have to be made by different authorities.
Director
Has to be done by the opposite party number 2, but after seeking information from various authorities. That is the university. considering the submissions the time for the IA number 14549 is allowed, and time for compliance of the writ order is extended by 12 weeks. However, the matter is directed to be posted on 9th of January 26, so that the opposite party number 2 may place on record the progress made in the case. ठीक है, क्या क्या प्रोग्रेस हो रहा है, किसके पास चिट्ठी लिखे हैं, क्या कर रहे हैं, सब बता दीजिएगा। इसको हम लोग मॉनिटर करेंगे, ठीक है। हर 15 दिन में डेट देंगे कि कहाँ क्या चल रहा है। जहाँ आपको इम्पीडमेंट होगा आप बताइएगा, उसको भी पार्टी बना देंगे। It is expected that the opposite party number 2 shall take all appropriate steps to comply the order passed by this court within the extended period. ठीक है? The affidavit be filed by 7th of January.
Item 42, Contents Bill 1139 of 2025.
Earlier time was granted during last time.
Lordship may kindly come to the order dated 6 September 2025. They themselves prayed for the time, and the time was allowed till 17th of October. More than almost a month is passed, but they have not filed any show cause or compliance.
So we have completed lots of last instance, lots of
What is the appeal number?
Appeal number is Land Enforcement Appeal number 1 of 2023 and 2024.
You have been dispossessed. Have you been dispossessed?
Yes, Your Lordship. I have not been allowed to go into the property. The respondent number 6, that is the circle officer, he has restrained me from going to the property. Your Lordship.
क्या चल रहा है? बताइए।
If I win with the relation, I would like to point out one more thing. When the direction was there for the respondent number 3 to dispose the matter within 1 month, what he has done, he transferred the matter to the ACM. And since there, the matter is pending.
one week or 2 weeks time we will also take it.
Record का proceeding का record मंगाइए। You produce the records. आप record मंगाइए। क्या कर रहे हैं? ऑर्डर होने के बाद से अब तक क्या क्या हुआ है, सारे रिकॉर्ड प्लीज करें। Contents Bill 1139 of 25. Counsel for the parties are present. Counsel for the petitioner submits that the petitioner has been dispossessed and Land Encroachment Appeal number 1 of 2324 was pending before the Deputy Commissioner Lohardaga. The Deputy Commissioner Lohardaga was directed to dispose of the appeal in terms of order dated 3/7/23 passed in WPC number 3005 of 23. But the order has not been complied, and the plaintiff and the petitioner is deprived of his property. Counsel for the opposite party has submitted that some more time be granted to file compliance report. However, no petition seeking extension of time has been filed, nor any specific reason has been stated by the counsel for the opposite party as to why the order of this court has not been complied. The matter relates to deprivation of the petitioner of his property, of property claimed by him. The counsel for the opposite party is directed to seek instructions from the Deputy Commissioner Lower Daga and file an affidavit stating as to what steps have been taken after order dated 3/7/2023 with all supporting documents, and what is the impediment in complying with the order dated 3/7/23. 14 तारीख नहीं 28 तारीख post on 28. The affidavit should be filed by 25th.
From supplementary list of final disclosure item 1, first appeal 138 of 2023.
Yes, madam.
Clear number 43, what is that directing the London court to read the status in the matter?
What happened? Serial number?
43, just
Last.
What happened in this case? What is the
This is a restoration case here.
Okay, what is the status?
That have not seen it, but they have
Restoration of?
restoration of this criminal division here. Which has been dismissed due to non-renewal of defects here. And after my one year I have removed all the defects here. And thereafter also it has dismissed.
It was again extended.
My lord, this is the second time we are filing this. Thereafter, appealing,
What is the status report?
it
That
is
has not been received.
is only point of statement of the accused here. But in the criminal division here, I have taken the ground that there were two 311 application was filed. One was filed by the complainant and I have also filed. That too after the conclusion, after the disclosure of all the evidences by both the parties. There the 301 application was filed by the complainant bringing record certain documents. I have also made similar similar application for bringing some my documents here. Now their 311 application was allowed and my 300 application was dismissed. Only on the ground that as the application of the complaint under section 311 has been allowed, therefore there is no the infractions.
What is CRMP number 8872 of 788872 of 25?
7/8 of 2024.
25 ये क्या है? ये फाइलिंग नंबर है क्या? नीलम
CNP 1918.
1918 डिफेक्ट वाला होगा ये. What is the present status that has not been received as yet?
But my lord, on the last occasion directed the kindly when was the last order now? 26 September 2025. Office directed to call for a report regarding the present status of the opposite complaint case from the court concerned. I have
यहाँ पे लोग लिखते भी नहीं है कि रिपोर्ट आया है कि नहीं आया, चेक ही नहीं करते. यहाँ पे लिखना चाहिए ना रिपोर्ट आया है कि नहीं आया. इसका ऑफिस रिपोर्ट करें. CRMP नंबर 1918 of 25. In in terms of order dated 26 September 2025. No report has been received from the concerned court. Post on next week. Right.
Supplementary list for finance for item 1, 1st April 138/2023.
It was further asserted by the dependent number 1 and 2 in the written statement that BN holding number 242 plot number 58/1564 area 1 acre and Orchard lease holding number 242 plot number 58/1566 area 2.04 acre was renewed. So Orchard is 243. Wrongly typed means I'm reading it right from the written statement. Written statement. I'm reading it right from the written statement. I don't take it from the judgment ever. I'm reading it from the written statement. This is what is written in the written statement. It should be 243. ऊपर लिखा हुआ है. There is an error. 243 कर दीजिए. Was renewed in the name of Lessees Ranjit Lehdi and Dr. Abhijit Lehdi. For the period from 1 period भी गलत लिखा है. खाली was renewed लिख दीजिएगा. And the renewal of building lease for the period 1/4/2008 to 31/3/38 was under process. It was also stated that the order of the Deputy Secretary Department of Revenue and Land Reforms, Jharkhand Ranchi, for renewal of the orchard lease holding number 243, lot number 58/1566, area 2.08 acres, for the period from 1/4/2008 to 31/3/1938 was received, but deed of lease was not yet registered. It was a case of the defendant number 1 and 2 that defendant number 3 had no right to transfer the land without permission of the competent authority of the government of Jharkhand, and that the office of Khasmail Hazaribagh had not received any application for permission to transfer of land of the BL holding lease or orchard holding lease. The said defendants had no information about the agreement to sale dated 17/12/2014 between the plaintiff and the defendant number 3, or with regard to payment of any consideration amount with respect to Schedule A and Schedule B property. The defendant number 3 had no right to execute any agreement with respect to the Khasmail lease holding number 242 and 243 of Mauza Khurra in favor of the plaintiff without permission of the Deputy Commissioner Hazaribagh. It was also mentioned that on an inquiry of the land under holding number 242 within bracket BL and 243 orchard, bracket orchard, by the officials of Khasmail, it was found that the lessee does not reside in the residential house constructed over the BL holding lease. Two persons, namely Devanandan Lakra and Ashok Mehta, live there as caretaker in the premises. The learned trial court framed the following issues for consideration. The plaintiff led both oral and documentary evidences. Which are as follows. चार्ट बनाना होगा, इसमें चार्ट नहीं बनाना, चार्ट नहीं बनना चाहिए, ये लाइए, yes, para 8 है in Jharkhand. So far as the defendants are concerned, no oral or documentary evidences has been adduced on behalf of defendant number 1 and 2. And the proceeding against other defendant number 3 and 3A was expired. The learned trial court first decided the issue number 7 and 8 and held that the plaintiff was neither willing nor ready to perform his part of the contract by perform is part of the contract. And also held that the contract itself and also held that the original defendant number 3 had no right to execute the agreement of sale in favor of the plaintiff for the Khasman land. And the agreement itself was not capable of being implemented as it was not certain and it was neither certain nor capable of being made certain, and held that the agreement was a void document which could not be enforced by law. And accordingly, issue number 7 and 8 were decided against the plaintiff. With respect to issue number 1, 2, 3, issue number 1 to 6, the learned court held that the suit was not maintainable in the present form and that there was no cause of action and so far as non-joinder of necessary parties and validation of the suit is concerned, the defendants failed to prove and adduce relevant evidence on the point. And ultimately, the suit was dismissed by the bench judgment. The learned counsel for the appellant, while assailing the impugned judgment, has submitted that readiness and willingness to perform on the part of the plaintiff was duly proved. He has submitted that the statement of the bank accounts were produced to show payment made earlier and also to show the readiness and willingness to perform the remaining part of the contract. He has further submitted that the availability of the fund with the plaintiff was also proved by referring to Exhibit 3/5, which was the bank account of Messrs. Ma Lakshmi Belcon Private Limited, in which the plaintiff was attached. And was also the authorized signatory. The learned counsel further submits that so far as renewal of orchard is concerned, the same was renewed. The order for renewal of the same was passed way back on 25/2013, and the requisite amount of rupees 578,381 was also deposited by defendant number 3. And the application for renewal of lease was pending consideration, which is apparent from the letter dated 16/2/2015 issued by the Secretary of the Government of Jharkhand to the Deputy Commissioner Hazaribagh, in which the case number being 48 of 2007-8 along with other case numbers has also been mentioned. However, admittedly there is nothing on record. However, during the course of arguments, it transpired that there is nothing on record that application for grant of lease to the plaintiff was ever filed by the defendant number 3, by the original defendant number 3. And admittedly the renewal of lease with respect to the orchard was yet to be registered. Abhijit Lahiri is defendant number 3. Further, it is also not in dispute that Abhijit Lahiri is defendant number 3, but as per the claim, a case of the plaintiff itself, The lease was in favor of Ranjit Lahiri and Abhijit Lahiri.
Ranjit Lahiri defendant number 3. Abhijit Lahiri was his brother.
Ranjit Lahiri was defendant number 3. And the amount was defendant number 3, and the lease was in lease of the Khasmai lease was in favor of Ranjit Lahiri and Abhijit Lahiri. दोनों के नाम से था ना? However, the Learned Council has clarified the position by submitting that the sublease that the agreement of sale was in relation to only half share of the defendant number 3. The Learned Council has further submitted that non-renewal of lease by itself is not an impediment in grant of relief under relief seeking specific performance of contract. कल वो 3 जजमेंट था ना?
जी. ये 7
कल
मतलब ये
आपको दिए ही थे कल.
हमने दी थी तो आप मतलब बोले कि पैरा लीक कर दे देते.
हाँ.
बुक भी दे दिए 2007 का 10.
For this purpose, the Learned Council has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2007 bracket close 10 SEC 595 within bracket Vishwanath Sharma versus Shyam Shankar Goyla and another. And I submitted that where the vendor had agreed to sell property which can be transferred only with the sanction of some government authority, the court has the jurisdiction to order the vendor to apply to the authority within specified period, and if the sanction is forthcoming, to convey to the purchaser within a certain time. He submits that it has been held that there is always an implied covenant on the part of the vendor to do all things necessary to effect transfer of property regarding which he has agreed to sell the same to the vendee. And permission is not a condition precedent to grant a decree for specific performance. He has also relied upon the judgments of 1, 2, 3, 4, 5.
पे 2010 से वो जो है वो दूसरे पॉइंट
2019
वो है
दूसरा इस पॉइंट पे कौन सा?
2010 से सीवी.
He has also relied upon the judgment reported in 2010 capital SAR within bracket civil bracket 2645
paragraph 2 which
within bracket Lakshman, Tatyaba, Kankati and another verses Taramati, Harishchandra, Bhadrak.
There are two easy facts.
And para?
There are two easy facts in which appellate court has directed to get permission, and para 13 is
The
a
Learned
law.
Council has referred to paragraph 2 of the state judgment to submit that the first appellate court in the state case had directed had granted the decree for specific performance of contract upon grant of permission of the competent authority as contemplated under section 12 within bracket C of the Maharashtra Resettlement of Project and Displaced Persons Act 1976. While considering the judgment of the learned first appellate authority, the Honorable Supreme Court has held in paragraph number
13.
Paragraph number 13. To submit that, it has been held that the principle that the jurisdiction of the court to grant specific performance is discretionary and role of the plaintiff is one of the most important factors to be taken into consideration. And that the court is expected to take care to see that the process of the court is not used as an instrument of oppression to give an unfair advantage to the plaintiff as opposed to that of the defendant in the suit. पैरा 13 आप बोलोगे ना? Sorry, एक सेकंड, ये जो पैरा 14 का रेफरेंस है ना, उसको काट दीजिए, पैरा 13 का रेफरेंस. To submit that in the said case, section 13 within bracket 1 within bracket C of the Specific Relief Act 1963 has been taken into consideration, which clearly postulates that where a person contracts to sell immovable property with an imperfect title and the property is encumbered for an amount not exceeding the purchase money, the purchaser has a right to compel the seller to redeem the encumbrance and obtain a valid discharge and then specifically perform the contract. The Learned Council has then drawn the attention of this court to the provision of section 13 within bracket 1 within bracket B of the Specific Relief Act. दिखाई दे specific. To submit that in a case where concurrence of other person is necessary for validating the title and they are bound to concur at the request of the vendor or lessor, the purchaser or lessee may compel such vendor to procure such concurrence. and बस इतना ही तो
ठीक
हाँ, to procure such contents. यही तो जजमेंट है आपका इस पॉइंट पर. By referring to the aforesaid two judgments, the learned counsel for the appellant has submitted that even if the renewal of lease, the process of renewal of lease was not complete, the trial court was required to take into consideration section 13 with bracket B of the Specific Relief Act 1963 to direct the defendant number 3 to take all steps for the purposes of renewal of lease and also for grant of permission for transfer. He submits that the finding of the learned trial court that the agreement was void in view of section 29 of the Indian Contract Act is not in accordance with law. यही है आपका?
हाँ वही पार्टी क्लियर
बाकी जजमेंट आप किस पॉइंट पे दें?
2019 6 SCC page 233
2019 6 SCC page number
233
233. The learned counsel has also relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2019 bracket 06 SCC 233. Bimani Mahalakshmi versus Gangumala Apparao. Paragraph?
Paragraph 14 मैंने अगर डिफरेंट अगर वेंडर अपने पार्ट को परफॉर्म नहीं करते हैं तो बैलेंस लेसर जो है वो इनकंसिक्वेंस है.
To submit that if the vendor does not perform his part of the contract, then availability of balance consideration amount is inconsequential. यही बोल रहे हैं?
Yes. तो इसी पॉइंट पे 70 सुप्रीम कोर्ट पैराग्राफ 6 हम लोग ये है 20
ये जरा पैरा 14 रीड कर लीजिए. कल ही साइट की केसेस
नहीं करने के लिए बोले कि नहीं करना.
पढ़िए.
Therefore, on conjoined reading of a limit such and such and the reply to be voted by the defendant vendor and the cross-examination of the defendant vendor, both the learned trial court and the high court has rightly observed again that the appellant vendor that did not perform her part of the contract thereafter was recorded. Once the finding is recorded that it was the appellant vendor that did not perform her part of the contract, therefore rightly observed by the high court, the failure on the part of the vendee to demonstrate that he was having sufficient money with him to pay the balance sale consideration by the date of
That's
evidence.
it. Paragraph 14. No? The learned counsel has further submitted that the finding of the learned trial court on the point of readiness and willingness on the part of the plaintiff to perform his part of the contract is not in accordance with law when seen in the light of paragraph 14 of the aforesaid judgment. Right?
Yes.
इसके बाद कौन सा judgment?
इसी 70 वाले paragraph 6 में
The learned counsel then referred to another judgment on the same point, which is reported in AIR 1970 SC 546 within bracket Nathulal versus Fuljan,
Paragraph 6, second line.
paragraph 6, 7 and 8.
6, madam, only 6.
Okay, paragraph 6.
Second line. To prove himself ready and willing, purchaser had not necessarily to produce the money, but to vouch a concluded scheme for finance.
paragraph 6 में तो ये नहीं है.
सत्तर सुप्रीम कोर्ट पेज 546 का पहला 6 सेकंड पेज पे है मैडम.
Second page, Fuljan could
हाँ, could be called upon to pay only after उसमें फुलजाम वही थे purchaser थे. उसके बाद second line में to prove himself ready and willing, a purchaser had not necessarily to produce the money or to beg to vouch a concluded scheme for financing the transaction.
The learned counsel has referred to paragraph 6 of the aforesaid judgment to say that it has been held that in order to prove that the purchaser was ready and willing, the purchaser need not necessarily produce the money or to vouch as a concluded scheme for financing the transaction. The learned counsel for the appellant has submitted that the plaintiff had produced enough material on record to show the availability of fund, which was enough to show readiness and willingness on the part of the plaintiff. But this aspect of the matter has not been properly considered by the learned trial court. और कोई आपका judgment sheet है? नॉन जॉइंटेड पे आपको क्या बोलना है?
नॉन जॉइंटेड पे बोलना था कि सेक्शन 44 है और उसमें इसके अलावा उसमें कि ये अनडिवाइडेड एग्रीमेंट से क्लियर है कि अनडिवाइडेड शेयर का वो अपना की ये नहीं कोई कि हाफ शेयर ऑफ दी सच प्रॉपर्टी का की और in view of the specific provision in contained in section 44 of the transfer of
property act
के undivided proportion can be share of
बट इसका तो रिन्यूअल दूसरा पार्टनर दे दिया है.
रिन्यूअल तो हो चुका है तो वो तो केवल अब एप्लीकेशन सबमिट हो इस पे एक जजमेंट भी है.
ये बताइए सेक्शन 44. The learned counsel has further submitted that the suit was not bad on account of non-joinder of necessary party, inasmuch as the co-owner of the property, namely Abhijit, क्या नाम है? अभिजीत.
ये co-owner है अभिजीत जो एग्रीमेंट किया वो रंजीत है जो co-owner है अभिजीत.
Abhijit Larry was not party to the proceedings. Inasmuch he has submitted that under section 44 of the Transfer of Property Act, it has been provided that when one or two or more co-owners of removed property legally competent to transfer his share, the transferee acquires such right or interest so far as it is necessary to give effect to the transfer, and then to enforce a partition of the same.
लीगल नेसेसिटी था क्योंकि एग्रीमेंट में लिखा हुआ है कि अपना ट्रीटमेंट के लिए पैसे देंगे.
But the same is subject to the condition and liabilities affecting at the date of transfer. with respect to the share or interest so transferred. The learned counsel submits that it was only on account of legal necessity that one of the two co-owners, that is original dependent number 3, entered into an agreement with the plaintiff
For his treatment.
for his treatment. He submits that taking into consideration section 44 of the Transfer of Property Act, the suit was not bad for non-joiner of necessary parties. He has submitted that the plea of non-joiner of necessary parties has been rejected by the learned trial court also. तो आपके फेवर में डिसाइड किया और कुछ बच्चा है the learned counsel for the respondents number 1 and 2 has opposed the prayer. They had opposed.
Just to the
Supported the petition. They had opposed or not?
I have to say that the contract was not certain and release was not executed.
Has submitted that. Has opposed the prayer and has relied upon the written statement filed by defendant number 1 and 2 before the learned. He has further submitted that the lease of both the properties were not renewed, inasmuch as in connection with orchid only permission was granted and the lease deed was yet to be executed by registration. And so far as the building is concerned, the lease deed was, the application for renewal was still pending. The learned counsel has also submitted that no application for renewal was filed by the plaintiff, by the defendant number 3. No application for permission to transfer was filed by the defendant number 3 or his co-owner with respect to the suit property, and accordingly the entire and accordingly the arrangement made between the plaintiff and the original defendant number 3 is not binding on defendant number 1 and 2. Very good.
Section 13(1)(b), suppose that in that section, I think it says, when a person contracts to sell or create certain immovable property having no title or imperfect title, the purchaser or lessee has the following rights, namely, in B, where the concurrence of other person is necessary for validating the title and they are bound to concur at the request of vendor or lessee. In this section continues. In the present case, the defendant 1 and 2, the respondent 1 and 2 are not bound to concur.
The learned counsel has also referred to section 13 within bracket 1 within bracket B of the Specific Relief Act 1963, and he submits that twin conditions are required to be satisfied to attract first part of section of the aforesaid section, which has been relied upon by the plaintiff, by the learned counsel for the appellant. He has submitted that there is no dispute that concurrence is necessary, but at the same time, the dependent number 1 and 2 are not bound to concur at the request of the vendor. He has also submitted that they also have right to put certain terms and conditions, as has been put in connection with in connection with renewal of the lease relating to orchard. The learned counsel submits that there is no concept of automatic renewal of lease upon filing of application, and therefore the terms and conditions of the agreement was itself uncertain, and such uncertain agreement cannot be enforced through specific performance of contract. He submits that the learned court has rightly held that the agreement itself was void inasmuch as no prior permission was taken from the dependent number 1 and 2 to deal with the property. And the conduct of dependent number 1 and the plaintiff is not binding on the dependent number 1 and 2, and it is ultimately the title ultimately the title vests with dependent number 1 and 2, and by praying for specific performance of contract, it is the property of dependent number 1 and 2 which is the subject matter of consideration. Okay? 1:30 बजे उठना जरूरी है आज।
वो भी तो क्या है उसके बाद
ऑर्डर रिजर्व करनी। आर्गुमेंट्स कंक्लूडेड।
खाली एक और जजमेंट दिखा दे कि ये हो गया 2003 का 2 जेएलजेआर
कहाँ
जो कल हम बताए थे दे रहे थे 2003 का 2 जेएलजेआर पेज 293 कि रिन्यूअल एप्लीकेशन विदिन टाइम होता है तो ये ऑटोमेटिक होगा जो कल हम आर्गुमेंट किए थे।
हमारे पास नहीं है जजमेंट, नहीं ऐसे नहीं है और जजमेंट बिना लाए
ठीक मैडम 2003 volume 2 JLJ page 293 I bar I was undertaking
ऐसे बिना जजमेंट देखे हम ऐसे साइड
ठीक है in regard to I have to submit that once application for renewal is accepted
the learned in response to the learned argument of the learned counsel for the in response the learned counsel for the appellant has submitted that has referred to the judgment passed by
our own High Court
this court reported in
2003 2 JLJ page
2003
volume 2
volume 2
JLJ page 293
JLJR
page 293
293 para number
in which it has been held at High Court renewal of lease is
and submits that it has been held that renewal of Khasman lease
yes is mere formality
is a mere formality
पार्टी ने भी जगह का नाम फर्जी है 10
is a mere formality
नहीं मतलब केवल application has to be submitted application for renewal has to be submitted
and the condition is that the application for renewal has to be submitted within
Right.
time. Automatic कैसे होता है?
जैसे उसमें इसका म्यूचुअल है ना उसमें है कंसिस्टेंट जजमेंट है ये भी जजमेंट जो है वो डिवीजन
आप प्लेस नहीं करते हैं, अपना मोबाइल से प्लेस करते हैं,
नहीं
हमको
मैंने
तो समझ ही नहीं आता है कि हम क्या कल तो नहीं जेल दिए थे कल तो नहीं दिए। ऐसे आर्गुमेंट आप हवा में करिए, इसका क्या रेलेवेंस है? I will. How do I know?
No, my lord, I am saying.
The judgment है ना कुछ है, हम बस नोट कर लें आपका.
Then I am saying, my lord, that as per the Khasman, my lord, the once this is perpetual in nature, and once lessee has applied for renewal within stipulated time, and in this case, both renewal was pending under consideration of the admitted party. Case number 4, case number was said. Now it was to be mere formality, and it was to be done automatically. This is my reply.
Concluded.
You can
हम एक डेट देंगे, अभी नहीं देंगे. तुरंत हम आपको डेट में बता पाएंगे. But a date will be certainly. ये जो जजमेंट है ना, जो रेफर किया वो सारे जजमेंट्स एक जगह कर देंगे, वो पैराग्राफ भी सब एक जगह कर देंगे.